Hello, and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Tom Bergert, and today I'll be joined by my colleagues Clint, Brannon, and Craig Mytelka, both of whom are partners in our IP practice here at Williams Mullen. Today, we're discussing IP litigation trends and whether large IP litigation damages awards are here to stay. This is the first episode of a two-part series. Hi, Clint. Hi, Craig. How are you guys doing?
I'm doing fairly well. The weather is very icy today when we're recording this, so kids are out of school, so it's interesting. How about you, Tom?
Pretty good. I'm almost getting numb to the high numbers that we're seeing all around us in our field and around. Look at the companies that we have in the U.S. with market caps going over $1 trillion. I think there was a baseball signing the other day for a 9-figure amount over many years. It just seems like the numbers are getting higher and higher in our world of IP. And Craig, you can weigh in on this too. It just seems like we're seeing some very large IP damages awards, and I know we've got a lot to talk about, so why don't we start off with patents? And just so what everybody knows what we are talking about, maybe you guys can provide a short list of some of the high damages awards that we've seen in the last year or two.
Yeah, Tom. I mean, we've had 4 or 5 cases here just within the last few months or a year or so that have been hundreds of millions, over $1 billion in many instances. One of them is the recent Centripetal Networks versus Cisco case that was here in the Eastern District of Virginia, and the award was $1.9 billion. We also had a Caltech versus Apple and a Caltech versus Broadcom cases, and we had $1.1 billion in damages coming out of that. By comparison, we had a smaller case, only $109 million versus Apple. That case was brought by Wyland. We've had some Apple's, as you can see, is a favorite target in a lot of these awards, but we also had a $506.2 million award to Panoptis that was against Apple. And then here, just now as we're recording this, hot off the presses, is a $2.1 billion award from the Western District of Texas, VLSI versus Intel. And so that's one of the largest ever, if not the largest. So it's getting a lot of attention right now.
And it doesn't seem to me, and you guys can comment on this, but it doesn't seem like these are outliers. It seems like this is possibly part of a trend, which is what we're here to discuss. How did we get here with these high damages awards?
You know, Tom, there's been numerous reasons for why you're seeing this expansion in the amount of awards, not the least of which is there's a lot more patent litigation now than there used to be. And the technologies have become more complicated. There's a lot of emerging technologies out there, and companies are fighting for their market share of these technologies. And so as new technologies have arisen, and there's a tremendous amount of money being flown into these markets, it tends to raise the amount of litigation. So for instance, there is a lot of activity now surrounding autonomous vehicles. Well, this is an emerging technology that's just come up over the last couple of years, and literally billions of dollars of research are being put into it by some of the largest companies in the world. And so they're looking for a return on their investment, and they're looking to protect their market share. And the numbers get driven up so high in these jury awards because of the promise of huge amounts of profits and a huge amounts of investment and huge numbers in the amount of sales. In fact, even less sophisticated technologies surrounding sort of smokeless tobacco that people, now refer to as vaping, have become a huge market share. So in fact, Juul Labs, one of these smokeless tobacco vaping companies, actually filed over 46 patent suits in Q3 in 2020. And so the activity from these things has increased greatly. I would say the other reason you're seeing such a marked increase is over the last couple of years, there have literally been hundreds of companies in the venture capital arena that are getting into what they call patent litigation financing. And so what's happening is they are more directly mining technology and more directly analyzing the market space for areas where they think they could go ahead and bring a lawsuit. And, you're having a lot more sophistication put in on the analytics on the front end of these cases to determine, their viability. And so all of these factors are coming together in a perfect storm and are raising the specter of more litigation, much higher award amounts. And one thing I would add, it's not just in juries. In fact, in the Cisco case that Clint referred to a minute ago, it was actually a bench trial. And so I think it's covering a large spectrum of technologies, different types of cases, different kinds of circumstances in which the cases are being brought.
I think that's right, Craig. And what we're seeing is the frequency of these huge awards is increasing. It's not new to have $1 billion patent award. We've had many of them in the past, but in the past you would have one every few years. We had one in 1991, for instance, involving Polaroid and Kodak. Then we had one in 93, but then there weren't very many for many, many years. And then in the late 2000s, early teens, we started getting a couple of more, and then it was quiet again. And then the last three or so years, we've seen many of them. And I think it's because of what Craig said, is these are areas that are drawing huge amounts of investment and funding, and the market hasn't really shaken itself out yet as to who the leaders are going to be. And in some cases, they're deciding that in part by litigation.
Yeah, and it sounds like from what you both are saying that it's not just all jury trials. It's not in one specific court. It's not one specific technology. So it doesn't seem like there's a lot of predictability other than the fact that these are going to be here, these types of litigations. And given the damages are based on lost profits or reasonable royalties, are you guys seeing the cases with large awards based on a high volume of infringing products? Are they higher profit margins, higher royalty rates? What consistencies might we gain insight into from how these damages awards are being awarded?
Yeah, well, it's a mix, and some of them are based on a reasonable royalty. Many of them are, in fact. Some are based on a lost profits theory. But one thing to look at in the context of this is about 10 years ago, the Federal Circuit really started cracking down on damages methodologies in patent cases, and it started throwing out some ways that folks used to determine their damages. The so-called rule of thumb, which was 20% of the infringer's profit could go to a royalty that was kicked out as not being sound. They started really applying the so-called entire market value rule, which means if you want to base your royalty on the entire product as it's sold to the consumer, you have to show that your patent was the basis for customer demand, it's really tough to show that in most cases anyway, that one feature is what's driving customer demand for a product. And they started doing a lot of increased scrutiny of damages experts and awards and kicking opinions out. And what's kind of shaken out in the last few years is the damages experts have gotten far more comfortable and familiar with what the Federal Circuit's looking for these days. And they're able to offer opinions that stand up to this scrutiny and are frankly more sound and backed up more, and they include less guesswork. So that's one reason we're seeing more damages awards. Another thing that we alluded to is some, but not all of these, but some of these larger awards are just due to the fact that the company being sued happens to be a market leader in a particular market. And so, Apple and Samsung and Cisco, those kinds of companies, they tend to be have huge shares of their relevant markets. And so that just means any award against them is going to be larger. Maybe 10 or 15 years ago in the cell phone space, you might have had, 10 companies that had the share that Apple and Samsung have now. But now that's sort of aggregated into a couple of companies, which just leads to fewer awards, but higher damages. Now, that's not the entire story, though, because some of these damages awards are growing larger, even in the situation where it's a relatively small company. So it's a mix of sort of industry aggregation and leading to bigger awards, and damages experts getting better at what they're doing. And frankly, like Craig said, the cases being brought today are frankly better cases because of the upfront diligence that sometimes comes with litigation, finance, and investigation. So those are some of the issues. I don't think juries are one factor, but as Craig mentioned, the bench trial, the Cisco case was a bench trial, so that's not causing this in and of itself.
I think, Clint, the other thing you have to look at, and I think it's true with judges, but it's certainly true with juries today, that pop culture is playing a particular role in these jury verdicts and in these verdicts in general getting larger. When we try to take a case, you want to look at the curb appeal of the case and how it sits in front of the jury. And so what's happening is the public, through various media outlets and sources, are now getting accustomed to hearing about, particularly in technology fields, about the huge amount of money that's being transferred around and the rise of the billionaire and the tech giants out of Silicon Valley and all that. So juries have become somewhat desensitized to having these giant numbers. And so when you have credible evidence being put in front of them, and they look at sometimes the conduct of the parties, did it seem like that the one side or the other was being particularly arrogant or unreasonable in its actions, and how they come across and portray that to the jury? Juries tend to get angry. Juries tend to be savvy enough to understand that there was a wrong done here. And because they're accustomed to hearing these larger numbers, they are more likely than they would have been in the past to award significant damages, almost in a form of punishment for the conduct of the wronged party. And so I think pop culture in general has desensitized juries and allowed juries to go ahead and feel sort of untethered from what may have been traditional norms of 20 or 30 years ago, and are now awarding these giant awards. And I think it goes along with other market segments where you're hearing about, multimedia personalities and big numbers, across a variety of industries and in a variety of situations.
Yeah, and thanks for touching on that jury element too, Craig. I had a question for both of you in terms of the technology that's involved. Like I understand that in the Caltech case, we've got Wi-Fi chips that were embedded in something like 1.5 billion iPhones and iPads and MacBook devices, which just seems like an astronomical number. But very, very briefly, are the juries understanding this technology in your views? And if you're a plaintiff in these patent litigations, is your arsenal something where you're having a number of patents with a number of different claim types for the patent professionals that may be listening? Do they have system, device, and method claims? Are they one type of claim, or does it really run the gamut?
Yeah, I think in terms of juries understanding the technology and how that impacts things, it can cut both ways. Sometimes generally, if you have the better side of the case and the facts and the law are on your side, you want the jury to understand what your case is. But sometimes if the technology and attorneys tend to try to simplify the technology so both the judge and the jury can understand it. But I have seen occasions where it almost got simplified so much that the jury thought the invention was almost trivial. And so that could come back and hurt you potentially on the invalidity side of the case if the jury thinks that this technology, that if we can understand this, it must be easy. So it must not be that big of an invention, or it must not be worth much. And so I think depending on how you describe the technology, that can cut both ways. And I think really it has less to do with the technology and more, as Craig was talking about a moment ago, to issues related to the damages analysis itself. And is there a huge royalty base to which the royalty can attach? Did you lose a huge amount of profits? And they see these large numbers, they're sensitized to them today, and they see the evidence of that. And that's, I think, in most cases, easier for the jury to understand than the technology. And if you hear that a company made $10 billion selling a product over a couple of years, as a jury, it's pretty easy for you to award someone $1 billion as a reasonable royalty. So I think the complexity of the technology is almost neutral in the damages side of things. In terms of the type of claims, whether they're apparatus claims, method claims. Again, I think in the damages side of things, the jury's usually not looking at it at that level of granularity. And obviously the damages analysis as well as the infringement analysis are a little different for apparatus and method claims. And a lot of times it's harder to prove infringement of method claims, but the damages, from what I'm seeing, there doesn't seem to be a huge difference in apparatus versus method claims, as long as the amount of use is essentially the same.
Yep. Final question for this part one. If we had to summarize 2 to 3 key factors that may be consistent across the board in these patent damage cases, these high patent damages awards, can we do that, and what would you identify?
You know, Tom, I would say that building on what Clint had just spoken about, I think that one of the most important factors is that you need to walk the line between simplification and creating a good record. So it's very important in a patent case to have enough granularity on the record so that you can sustain your award, because obviously the larger the award, the more likely you are to face an appeal and then a protracted continuing litigation. And so I think in demonstrating the technology to the court, you need to make sure that both the court and the jury understand the technology. It's documented well enough between your client and whatever experts you use so that that is well established. Then the other part of it is what I call the simple is best. Juries tend to understand, what's put in front of them if it's done articulately. And so everybody understands walking into your garage and stealing a bicycle and driving it off. And so everybody understands fraud. Everybody understands theft. So you want to be adept at going ahead and explaining the technology so that you create a good record. But then you also want, in the simplest terms possible, to understand that, stealing a patent and stealing intellectual property is no different from somebody walking into your garage and stealing your bicycle. The conduct is wrong. People understand right and wrong, and make that part of the case simple, straightforward, and direct. And then allow your experts and others on economics to explain how much you've invested into your technology and how much you have lost by reason of this theft, and how much the other side has gained by reason of this theft.
Thanks, Craig. Clint, anything to add to that briefly?
I think that all makes very good sense, Craig, and I agree 100%. I think we touched on a few of the factors, just how things have shaped out in the last few years in the litigation world. But I think in general, some of these are high volume products, but again, that's not all of the cases. So that's not necessarily driving all of these huge awards. Second, you have the preparation that's going into the cases. And frankly, I think the cases that are filed today are generally on higher quality patents than what we saw 10 years ago. There's a lot of reasons for that. It's easier now to kick out a low quality patent early in the litigation, either through an AIA review at the Patent Trial and Appeal Board, or through an early motion to invalidate the patent as lacking patentable subject matter. And so because of that, people are frankly just not bringing weak cases anymore. And the quality of the patents and the preparation that plaintiffs are putting in is leading to more cases going to trial and ultimately more jury verdicts. And so you'll have some larger ones in there as well.
Gentlemen, thank you. That wraps up part one of our discussion on whether large IP litigation damages are here to stay. In part two, we will continue the discussion and delve into future forecasts, non-patent IP litigation damages, and other worthy topics. I'd like to thank you both, Clint Brannon and Craig Mytelka, for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our IP practice page at williamsmullen.com/IP. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.